Hello, my name is Lini Gamat, Metric 27769. I will present the fact of the Andaman Luxury Collection Resort case. Firstly, the Andaman Luxury Collection Resort had produced two witnesses, Vijay Kumar, Director of Finance of the hotel, and Tan Sri Dato Azman Shah bin Dato Sri Harun, who is testified his capacity as a council member of the Minimum Wages Council representing the employers. The hotel also requested to restructure the wages by top-up from employees' service fee to meet the statutory minimum wage of 900. Hearing of the case commenced on 15 March 2017. Both parties had filed their respective submissions and bundle of authorities. Oral submission was also heard, but both parties were not satisfied that they had fully appraised this court of their respective views, observations, and perceptions, which then went on to file for the written submission. The hearing mainly highlighted the issue of trade disputes in relation to the restructuring of worker wages in line with the implementation of the Minimum Wage Order 2012, which involved changing part of all service charge payable to be included in basic salary to form a minimum salary of 900 ringgit per month.
Hi, good morning sir. My name is Dineshwari Anak Perempuan Sima Salam. My metric number is 281723. So, let's look at the issues of the case. The only issue that was brought up for the consideration was whether the hotel had the right to restructure the wages of the employees by converting all or a portion of the service fee due to be combined with the basic wages to form the 900 ringgit monthly minimum wage. The hotel contended that the total salary paid to the employees would remain the same, both before and after the restructuring of the wages by converting all or part of the service charge entitlement into the basic salary to make up the minimum wages of 900 ringgit. In the event that the amount of service charge was not sufficient to make up for the minimum wages for any particular employee, the hotel would bear the differential sums to ensure compliance to MWO 2012. Employees in the hotel industry are paid a low basic wage because they are entitled to a portion of the service charge. Employees are usually entitled to a portion of the service charge that is actually collected under most collective agreements and awards. The hotel in this case took the decision to implement the MWO 2012 by way of top-up from individual employees' service charge, whereby for employees with a basic salary below 900 ringgit, the hotel would restructure the wages by converting all or part of the service charge entitlement into the basic salary in order for the employees to receive the minimum wage of 900 ringgit. That's all from me. Thank you.
Good morning, doctor and my friends. My name is Tarshin Devi and my matric number is 289574. Today, I will discuss about holding of the case. So, the I Court in the case of Lam Sung M. Berhad, Kesatuan Pekerja-Pekerja, Perkilangan Perusahaan Makanan 1998 LNS 354 held that the Industry Court cannot discard Section 34 of the IRA 1967 in making its decision. Industry Court had failed to have regard to the provision of 34 when making the award. There is no mention whatsoever in the award that the learned chairman had ever referred to and taken into account the provision of 34 of the Act in its decision. The Industry Court must act according to equity, good conscience, and the substantial merits of the case without regard to technicalities and legal form 30/5. The Industry Court nevertheless cannot discard the provision of 34 in its decision in this case. Based on the foregoing authorities, this court has wide powers to ascertain equitable and fair solution to trade disputes, and while doing so, the court shall have due regard to public interest, the financial implications and the effect of the award on the hotel industry as a whole. In order to achieve industrial harmony as entrenched in the preamble of the IRA 1967. Thank you so much.
Assalamualaikum and good day everyone. My name is Muhammad Firdaus bin Alias. My matric number is 270649. I will continue with the rationale of the holding part. As for the rationale of the holding for this case, Kesatuan Kebangsaan Pekerja-Pekerja Hotel, Bar and Restoran Semenanjung Malaysia, the union has the right and eligible to file suit against Andaman Luxury Collection Resort Langkawi, Andaman Resort Sdn Bhd. This case was all about issue restructuring the employees' wages by converting part or the whole of the service charge payable to be included with the basic wages to form the minimum wage of RM900 per month in compliance with the minimum wages order 2012. The union contend that it had already rejected the hotel proposal in this regard during a meeting held on 18 October 2013, but that the hotel had unilaterally approached with the state restructuring without the consent of the union or any variation being agreed hereupon. The union state that the restructuring of wages by the hotel was merely a mathematical calculation that was not in accord with the NWCC, the National Wages Consultative Council Act 2011, the Minimum Wages Order 2012, and the term of the fifth collective agreement. The union also further contend that since the negotiation had failed, the hotel unilateral topping up with the service charge to meet minimum wages was improper, as the appropriate cost would have been for it to be dealt with during negotiation, the for the union of the collective agreement, and not during the currency of this fifth collective agreement. Okay, next, the union further claimed that the hotel had failed to implement minimum wages, but by unilaterally converting part of service charge into it, the hotel had implemented composite wages, which unfortunately was left undefined by the union at trial, and which in turn the union claimed was not in accord with the NWCC Act 2011 and the MWO Minimum Wage Order 2012. The union further averred that the hotel unilateral conversion of survey charge in this manner hardly lead to the preservation of industrial harmony in this sector. To restate it, the union contend that the hotel had not obtained the consent of the union to vary the term of the fifth collective agreement, and by unilaterally topping up on the survey charge to make up the minimum wages, the hotel has infringed Article 2B of the collective agreement, which specifies that a deal with the variation to the term of the fifth collective agreement. That's all from me. I will pass to the next presenter.
Hello, my name is Nur Ala Shahira binti Sabah. My matric number 277102. Today I will talk the conclusion. In a conclusion, the involvement between two parties is relevant in this case by application provision including Section 64 of the Industrial Relations Act 1967, which requires this court in making its award in respect of a trade dispute to have regard to the public interest, the financial implication and the effects in the economy of country, industry concerned. Besides, to the probable effect in related or similar industry, bearing in mind Section 65 of the Industrial Relations Act 1967, which required the court to act according to equity, good consequence, and the substantial merits of the case without regards to technicalities and legal form. In the consequence, this court is unambiguous in its decisions and hereby order that the hotel is entitled to recruit the wage by converting parts of the world of the service charge payable to be included, and basic wage to form the minimum wage of 900 ringgit Malaysia per month in compliance to the minimum wage order 2012. I think that's all from our country. Thank you for listening.